The federal district courts are the lowest level courts on the federal tier. There are over 94 federal district courts in the country and at least one in each state. What does the authority of the federal district courts include? First, those cases that deal with a federal question whose issue is based on a claim within the U.S. Constitution. Second, cases where the plaintiff or the defendant is the federal government. And third, cases involving diversity of citizenship, meaning cases with people from different states or where the issue involves more than $50,000.
It's in the federal system where most of the big legal work of America occurs. But what happens when the people involved in a case within the federal district courts aren't happy with the outcome? They can move on up to the second tier and take their griping to the circuit courts in the form of an appeal.
The circuit courts, also known as the appeals courts, include 13 courts in the United States. These are courts which have no original jurisdiction.
Now, original jurisdiction refers to a court's authority to hear cases for the first time at the trial level. This is what the federal district courts have.
Instead, the appeals courts have appellate jurisdiction, which refers to the authority to review a case which has already been decided at the trial level. One thing to remember is that the appellate courts determine what laws apply to a case. District courts, on the other hand, determine the facts that decide a case. Appellate court cases are usually heard by a panel of 3 judges with no jury. District courts, on the other hand, are made up of 1 judge, and in the case that a trial is held, a jury of the defendant's peers.
So, getting to the appeals court is like getting another chance in the bull ring. There are 2 types of cases heard at this level. Those involving cases from federal district court and those involving issues in federal administrative agencies.
But what happens if after you've made it to the appeals court, you're still not happy with the decision?
You can try your best to take your case to the 3rd tier, the Supreme Court of the United States. The Supreme Court of the United States includes 9 members, 1 Chief Justice, and 8 Associate Justices. But getting to the Supreme Court is easier said than done. You'd probably have an easier time making it in Hollywood. This is what you've got to do.
First, buy a bus ticket to LA, then knock on all the agents' doors until one of them agrees to see you. Then wow them with your talent and good looks. Oops. Oh, that's how to make it in Hollywood. As far as the Supreme Court is concerned, getting to the Supreme Court involves getting onto the docket. The docket is the list of cases the Supreme Court members have decided to consider.
But getting onto the docket is a battle. To get onto the Supreme Court docket, you must first submit a brief, which is a document containing the collected legal arguments of your case, and you must include precedents. Precedents are prior judicial decisions that help support your side of the argument.
Parties must wait a long time before their case gets considered for the docket, unless it's an emergency of some sort.
And even after that long wait, chances are the court will end up making a decision of stare decisis. In Latin, stare decisis means let the decision stand. When a decision stands, the case does not get onto the docket, and it does not get heard in the Supreme Court. The ruling made in the lower court will stand.
If the Supreme Court justices accept your brief, they grant you what is called certiorari. Although it sounds like a monster Godzilla would fight, it's actually a review of the case. Being granted certiorari means that you are now on the docket. Getting this far is pretty impressive in and of itself, even if the court doesn't overturn the case in the end.
4 of the 9 justices must agree to accept a case before they grant a writ of certiorari. If the case gets to the Supreme Court, it may have a chance to shape history.